It is California Edition, and my name is Brad Pomerance, and his name is Roger Hernandez, and he is a member of the California State Assembly, and we are in his district today.
That's right.
We are in Irwindale in the San Gabriel Valley. Sir, I gotta say that I feel like your district, people don't realize how terrific it is. I mean, West Covina, there are some great malls in West Covina.
Absolutely, great entertainment, great restaurants, and a great place to buy a car. I would say my district is a great cross-section of California because it is diverse like California is, whether it's in its ethnic makeup or whether it's in its housing makeup. We have everything from your startup apartment to multi-million-dollar homes in the foothills.
But it's also a crossroads geographically, because you think about, downtown LA not too far, Ontario not too far.
That's right.
And so it really is a great crossroads for a lot of different areas in our great basin.
Beaches are 25 to 30 minutes away, and the mountains of Los Angeles here, the Angeles Mountains, are our backdrop. So it's a beautiful place, beautiful district.
Tough life you got, Roger Hernandez. Let's talk about those, though, that have had struggles when it comes to employment.
Yes.
We know that the days of working for Xerox from the age of 22 and kind of graduating in retirement, those days are done. And people are bouncing around, and companies are looking at different models to try to maximize the bottom line. Talk to us about a model that's taken off recently in terms of the temp worker.
Well, let me tell you, since the post-Great Recession, we have seen in the private sector the model of employment that's growing at 10 times the rate of any other private job is the employment of hiring folks on a temporary basis. A job that doesn't come with benefits, it doesn't come with a pathway to a pension. And so unfortunately, folks that are going back to work in this Great Recession era are going back to wages that are closer to the 1989 level. That's backed up from research out of the economists at UC Berkeley and UCLA. And that's unfortunate because today's economy has gotten more expensive to live in.
There's no doubt.
Housing, automotive, fuel, utility costs. So this model of hiring folks in this way is dangerous, particularly if a client employer, if a direct employer is cutting corners, wage theft, not giving enough hours so that there's sustainability for their workers. What we're seeing is many of these larger employers are taking up what was once maybe 5% of their workforce to now 30, 40, and 50% of their were once direct hires, now under the category of temp workers with an intermediary temp agency or staffing contractor providing that workforce.
So there's nothing per se that your bill, which we'll talk about in a moment, does to change that model. I mean, government can only do so much, and it's a model that's being adopted. But at the same time, you are looking to protect those workers who are participating in this temp intermediary model.
Absolutely. My bill is not looking to outlaw the use of temp workers because there is a reasonable use for a temp worker, whether it's a pregnancy or an illness, some type of delay, long-term leave because of a hospital stay or surgery. But there should not be exploitation that comes from the use of a temp worker. So my bill says this, that when you use a staffing agency to supplant your workforce, then you will be responsible for any injuries on the job for work that's being performed on your work site. And my bill makes it really clear. 1897 says for work that's rendered on the property of the client employer, for work that's rendered, the work that's everyday, regular work of that industry, of that company on the workplace.
So you're looking at questions of workers' comp.
Yes.
You're looking at questions of overtime pay. You're looking at those types of questions.
Absolutely. Working conditions, those conditions that are created and kept in place by the client employer, the original employer, those that are benefiting from the work of the workers.
So does this let off the intermediary, the temp agency, or does it create joint and several liabilities? So both are liable if there's an issue.
This creates joint liability between the client employer and the temporary agency or the staffing agency company. Today in the law, there's been a lot of fuzziness in terms of who's responsible for what. This bill creates a bright line that when you're bringing workers onto your workplace, on your work site, whether you use an intermediary or not, you will be responsible for the treatment of those workers, the working conditions of those workers. An employer will now have, today there is a perverse incentive for the client employer to say, you're not our employer,
Right.
our employee, you work for that temp agency, you work for that staffing agency. As a matter of fact, employers want to stay under this model that's being exploited,
Right.
want to stay away from those communications with the worker so that they can say,
I see.
we don't have, those aren't our
Right.
employees. They belong to staffing agency A or B. And that's the perverse incentive there that we're looking to shut down.
So if there's an issue with an employee, whatever you want to call that individual, will they now turn to the staffing agency, to the employer, or both? How will it work? Do you know yet? Do we know? Do regs need to be written?
No. The law makes it really clear that both will be responsible.
Okay.
Now, this legislation does not prohibit what's in place today. What is in place today is the ability for a client employer to make sure that there's good contracts between themselves and the labor contractor or the temporary agency to protect themselves if the so-called labor contractor is violating labor laws, wage laws, worker protection type laws. So this is an incentive to hire more reputable actors that are in this industry of providing workforce, temporary employees. And there is and it goes both ways. So for the client, for the company, a corporation that has direct hires, and or that uses reputable companies, this legislation provides a playing level field because when you're competing in an industry where your competitors are using staffing agencies that are cutting corners and cheating workers and exploiting workers, there is a greater profit margin to be made on the backs of exploitation.
Sure.
This legislation says you can't cut those corners anymore, and there is that liability that you have when you bring on the labor contractors, when you can no longer point to others and say, we're not liable for these workers, they're not our employees.
I have to think the California Chamber of Commerce was not a fan of this bill. Am I correct when I say that?
They were not a fan of this bill, but let me tell you something. Many of their members, whether it was trucking, whether it was utilities, whether it was the temporary staffing agencies, members of the Chamber of Commerce came off of opposition to this legislation. There's a good reason for that.
Please.
Because we worked with them. They brought to us amendments that would clarify the relationship between client and employer. We put those amendments in place. For example, they brought to us amendments that would exclude businesses that were 25 employees or less. We did that.
Right.
We took out independent contractors because there are true independent contractors that do work for companies. They have been excluded out of this legislation. If you're in a company that has shipping that's being sent to you or sent away from your business, we have removed the shipping element out of this legislation. Now, if at the headquarters of a shipping company, if there is a worker abuse there because with temporary workers, that industry would be responsible under 1897. But in the act of shipping, and you're a client, you're a company, you're not going to be responsible for that. AAA, for example, there's call centers there, but when they put out a call and send out a tow, this legislation would not affect the work of that tow worker out there if they are involved in an accident on the street. So we made a lot of clarifications in the legislation to really focus on work that's being rendered on a work site of a company, whether it's aviation workers working at the airports, here at LAX working under the wing and where passengers on the plane are looking down below thinking those are workers of the airline company. Those workers, because they're working on the site of the client employer, will have the protections knowing that they that if there's workplace injury, if there's workplace abuses, that it's not just the labor contractor, but also the client employer that's responsible.
But as I understand it, the Chamber still called this a job killer bill, and Governor Brown has been reticent to sign job killer bills, whether they are or not, but he signed it.
He sure did.
And so what went right? How'd you do it?
Well, Governor Brown is seeing that this exploitive use of the temp agency and the labor contractor world is what's leading to the race to the bottom in terms of jobs in California. Governor Brown believes that if we are allowing this industry to grow, then that means California is going to be on the hook in subsidizing many of these workers.
His name is Roger Hernandez. He's a member of the California State Assembly. I'm Brad Pomerance. It's California Edition.